Resuming debate, the honourable member for St. Albert Edmonton.
Thank you, Madam Speaker. I rise to speak on Bill C-77, an act to amend the National Defence Act. It's a bill that makes a number of changes to Canada's military justice system that applies to members of the Canadian Armed Forces. Let me say, before I address the substance of the bill, to put on the record my thanks to the brave men and women of the Canadian Armed Forces for their service and sacrifice and duty to country. The men and women of the Canadian Armed Forces collectively represent the highest standards of excellence. CFB Edmonton is located minutes from my riding of St. Albert Edmonton, and many Canadian Armed Forces personnel who are posted at CFB Edmonton live in my riding and are an integral part of the communities that I'm so fortunate to represent in the city of St. Albert, as well as Northwest Edmonton, and I'm very proud to be their voice in the House of Commons. Madam Speaker, Bill C-77, broadly speaking, seeks to align the military justice system with modern-day criminal code amendments. Madam Speaker, without more, Bill C-77 is a good bill, and I'm going to address why I think Bill C-77 is really a step in the right direction. But before I do that, I think it would be somewhat helpful, just for context, to discuss the fact that we have two parallel justice systems in Canada, a civilian justice system as well as a military justice system, and to understand the rationale for that long-standing reality. And I think it was very succinctly put by Chief Justice Lemaire in the Queen and Genereux decision, wherein Chief Justice Lemaire stated that the purpose of a military justice system is, quote, to maintain the armed forces in a state of readiness. The military must be in a position to enforce international discipline effectively and efficiently. Breaches of military discipline must be dealt with speedily and frequently, punished more severely than would be the case if a civilian engaged in such conduct. As a result, the military has its own code of service discipline to allow it to meet its particularly disciplinary needs, unquote. So I would further add to that another aspect of the military justice system is the recognition that Canadian Armed Forces personnel can be situated anywhere around the world, and to extend that jurisdiction to Canadian Armed Forces personnel, whether they're operating in Canada or Afghanistan or Mali or wherever they may be. Now, the military justice system has done a lot of things really, really well. As Chief Justice Lemaire made reference to, he spoke about the need for a speedy process for justice, about a higher level of discipline, having regard for the fact that members of the Canadian Armed Forces are not civilians, but are held to a higher standard. But one area where our military justice system has not done as good of a job is to protect the rights of victims. And that's what Bill C-77 seeks to change. And what Bill C-77 does is it establishes a Bill of Rights. It incorporates a victim's Bill of Rights into the Code of Service Discipline. It's similar to the Victim's Bill of Rights that applies in the civilian context. The Victim's Bill of Rights, of course, being an important achievement of the previous Conservative government. What types of rights will Bill C-77 enshrine? Well, Madam Speaker, it will enshrine 4 pillars of rights for victims. One is the right to information. quite often, those who are victims find themselves in a very difficult position to understand all of the court processes. And so what the right to information under Bill C-77 means is that victims will have information at all stages, from the time the charges are laid, through the trial, through sentencing, and through the post-sentencing phase, at all stages. And that's really, really important, Madam Speaker. And in order to help ensure that victims do receive information at all stages, Bill C-77 does establish a victims liaison officer. A second pillar is that it will ensure that victims have the right to privacy, and that the privacy of victims will be treated paramountly. And that's important, particularly in cases, for example, involving sexual assault. A third pillar of rights for victims is the right to be heard at all stages of the justice process. That includes being able to provide a victim impact statement at the time of sentencing. This is something that is routinely done in the civilian court context, and it seems to me quite logical that it should extend to the military justice system as well. And finally, Madam Speaker, Bill C-77 provides the right to restitution, whereby it would require a court-martial to consider the imposition of a restitution order where there was a loss involved. So, Madam Speaker, all of those things are good. They're a step in the right direction. We support them. We strongly support protecting the rights of victims. I guess when we say there's no problem with Bill C-77, or on the whole it's a pretty good bill, is perhaps because it's a carbon copy of Bill C-71 introduced by the previous Conservative government. Now, while this bill will pass, hopefully sooner rather than later, and it's taken 3 years for the government to finally get around to literally copying and pasting a bill from the previous Conservative government. But nonetheless, I guess better late than never. But after Bill C-77 is passed, there are going to be challenges from the standpoint of implementation. And it's going to be up to this government to deliver. It's not necessarily going to be easy. We have, for example, the need for a victims liaison officer to be appointed. As I noted when I asked a question to my colleague from Calgary-Shepherd, in the context of the victims ombudsman, which is basically the same type of position in the civilian context, this government left that position vacant for a year. In other words, there was no one there to represent and be an advocate for victims in the civilian justice system for a year. Let's hope, Madam Speaker, that this government does a better job when it comes to appointing a victims liaison officer. And as my colleague, the member for Selkirk Interlake Eastman, has noted, we have the very recent decision, the court-martial appeal court decision of Beaudry, that could upend a real objective of this bill in as much as the Beaudry decision provides that in the case of serious offenses, that those offenses be tried in the civilian court system rather than in the military justice system, notwithstanding the fact that we have 3 Supreme Court decisions that provide that such cases should in fact be tried before the military justice system. So that is another wrinkle. But Madam Speaker, overall this is a good bill, and we will try to work cooperatively with members of government to put forward amendments where necessary and hear from as many witnesses as possible to pass the best possible legislation to protect the rights of victims. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The honourable member for Don Valley East.
West, sorry.
Thank you, Madam Speaker, and I want to thank you, the member from St. Albert, Edmonton, for his support of this bill, which I think is really a landmark bill in the fact that it is now entrenching victims' rights in a statute. And I just wanted the members' comment on the difference that kind of entrenchment or enshrining of victims' right within the statute itself, as opposed to outside the statute as being a soft part, but as a hard part of the bill. And if he has any comments on the validity of that and the importance of that.
The honourable member for St. Albert, Edmonton.
I thank the member for Don Valley West for his question, and I do think it's important, because what it does is it gives teeth to the rights of victims in the military justice system, something that has been lacking. With the passage of Bill C-77, those rights will be enshrined. There will be processes in place to ensure that victims are able to receive those four pillars, whether it be the right to information, the right to privacy, the right to restitution where appropriate, and the right to be heard at all stages of the court process.
Questions and comments? Questions et commentaires. The honourable member for Toronto Danforth.
Thank you, Madam Speaker. And one of the big issues in my community, well, really moment of celebration as far as legislation was passed, was C-16, and recognizing, adding rights into our human rights code, criminal code about gender identity and gender expression. So one of the things that I noticed about this bill, and I would really like to hear what my colleague across the way feels, is that how does he feel? Like, does he not feel it's a great improvement to add to this bill that an aggravating factor to be included when considering a sanction is whether the service infraction was motivated by bias, prejudice, or hate based on sexual orientation or gender identity or expression?
Member for St. Albert, Edmonton.
Speaker, I look forward to supporting Bill C-16 so that it can go to committee and that section of the bill can be carefully looked at.
Questions and comments? The honourable member for Selkirk, Interlake Eastman.
Well, thank you, Madam Speaker. I want to thank my colleague from Edmonton, St. Albert, for his intervention today and his knowledge on the justice system and the work that he does on behalf of the victims so frequently here in the House. And I would like him to kind of wrap up his comments, talking about how, he mentioned during his speech that it's kind of almost strange to listen to the Liberals talk about victims' rights when everything that we've seen from the government so far hasn't been about standing up for victims. And if you want to comment a little bit more about how the Liberals like to hug the thug rather than actually support the victims.
The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker, and it is true that the record of this government has not been a particularly positive one when it comes to standing up for victims. The fact that we've now waited 3 years for this bill to be introduced, I think, is instructive. We see another bill before the House right now to water down sentences for serious indictable offences in Bill C-75. We saw this government defeat a private member's bill introduced by the honourable member for Beauport, Bill C-343, which would make the victims' ombudsman truly independent by making them an independent officer of Parliament rather than housed within the Department of Justice. And finally, we saw the failure of this government to fill the victims' ombudsman position for nearly a year. Contrast that with the prisoners' ombudsman. Madam Speaker, do you know how long it took the government to fill the prisoners' ombudsman? It took them a matter of 2 weeks. 2 weeks for the prisoners' ombudsman, 1 year for the victims' ombudsman. I think it speaks to the priorities of this government.